Well, thank you, Greg, for being here with me today. For those who don't know you, could you please introduce yourself?
Of course, and thank you very much for the invitation. It's really a pleasure. So yeah, my name is Greg Lourie. I am a German qualified lawyer. I've been practicing international arbitrations for probably about some 12, 13 years. Time
Wow.
flies. And I hold degrees from the universities of Mainz and Frankfurt. I did my PhD in public international law at the University of Frankfurt. And then I've been practicing primarily with major law firms, international law firms, for most of the time in Frankfurt, London, Washington, Paris. Then I moved to the International Chamber of Commerce, the ICC, which I think we'll speak about later a bit. The biggest arbitral institution, arguably the biggest arbitral institution. And now I'm currently taking a quick sabbatical / career break, as I think the formal term is nowadays, to do a bit of academia, spend time with my family, and I'm joining Schellenberg Wittmer in Zurich as of January. So relocating from Paris to Zurich.
That sounds very exciting and very diverse as a career background. So maybe we could actually start from the beginning of your Parisian experience in arbitration. So if I remember well, you started when you moved to Paris. You started to work at Lourie, right?
Yeah, that's correct, indeed. I think that's exactly when we met. I think you were one of the very first people that I met moving to Paris. It might just have been literally the first or second weekend in Paris.
I actually can remember that. I remember that we had lunch.
Yeah, I remember in Lourie. It was a very lovely lunch.
So tell me, how was it at Lourie? What kind of cases were you doing there? What kind of clients did you work on?
Yeah, so Lourie, as such, had always a very strong basis in sovereign work, so work for states, state-owned entities. And for me, that was also the primary reason to move there. So from my background, I did a fair bit of commercial arbitration before joining Lourie, but I had always somewhat of a passion for public international law and investment arbitration. So the disputes that involve states are between states, investors and states, but also just general public international law. And this is something you sometimes read on a newspaper. So cases before the International Court of Justice, or questions of diplomatic immunities and protection, that someone's embassy was raided by a state, and the question is that permissible? Questions of maritime delimitation, where the borders between two states in the sea. So these kind of things that you usually do from a rather academic perspective. And Lourie had at that time, and still arguably has, one of the very few practice that was doing this. So it's just a very small niche, but a very interesting one. And I was excited to have the opportunity to do this. So that also is kind of the type of clients and cases that we had. So a lot of it was investor-state arbitration, so claims by investors against states for, let's say, an allegation of expropriation or other mistreatment by the state. A lot of state-to-state work, and a lot of advisory to governments on international law questions. So again, diplomatic immunities, maritime delimitations, what happened. And interestingly, that affects quite often some novel issues. So I remember we had one case or an advisory for a government that was worried now with the rising tide because of global warming and the erosion of shores. What actually happened? Does the border between us and our neighboring state shift? And what happens with, let's say, our installations such as oil platforms? All of a sudden, are they now in the territory of the other states? So things you would think are primarily academic, but actually happen nowadays as a result of global warming and other events, have actually become quite pertinent. So our clients in that respect were primarily states and state-owned entities. We worked little for private clients, at least in investor state arbitration. There was a very clear focus on state clients.
Mm-hmm. That's super interesting. And the kind of cases that you describe, they're almost make me think of geopolitics, like about where the border goes, how the climate affects your state of business. It's very interesting.
You're completely right. That's exactly what it is. Whenever you're working for states, or most times, I guess you're working for states, geopolitics is an quintessential element of it, and states' internal politics is a very important element. So you work with governments, and governments are motivated by a number of reasons. It's very difficult, different. I meant to say, working with government as opposed to, let's say, private entities and companies.
I can imagine. What would you say are factors that a lawyer needs to master when they work with governments and this kind of clients that you describe? Because I imagine just being a very good lawyer is not enough, because the environment that you describe is very polemic, very geopolitical. It's not just it's almost not just a matter of law, or it seems.
Yeah, I think the biggest difference is probably to some extent the client management, because you do need to adapt to the region, cultural specificities, and that of course holds true to some extent to companies as well. Speaking to a director of a German company is very different speaking to a director of a Japanese company, just because cultures are very different. But in government, you need to pay particular attention to the position of the person and the entire interplay that the person might have within the government.
It's very interesting, and I'm always interested about like the business acquisition side of things. Do you remember at Cleary how does one get a government as a client? Is it with tenders, or is there any other way? Do you recall how it happened back then?
Yeah, I think it's, to some extent, it's probably all of this. So there are just formal tenders, and for formal tenders, you apply, you need to fulfill the requirement, as in X cases in the region, taking into account the language requirements, and so on. Very formal, you're interviewed, you might come on a roster, you might be selected for a specific arbitration. That's quite straightforward. And also with governments, I think a lot happens on interpersonal relationship, meaning that the government official has seen you in action and very much like you. I think it's important to remember that government officials, of course, depends on a country, those responsible for litigious cases, they do not necessarily need to be to have been their entire life civil servants. Some of them might have been very well in a big law firm, have practiced for a decade, and then they decide, for whichever reason that might be, that they want to be in a governmental position. So they might know you very well from previous case. You might have worked together. You might have been opposing counsel. And a lot, maybe to add, is also cross-selling, especially within a big law firm. So if a law firm is doing certain work for government, there is a good chance that that might help also getting the specific litigious cases. Practical example is Cleary has always had a very strong practice in sovereign finance, so helping states to restructure their debt. That is a topic that is quite closely connected to investor state arbitration, So a lot of cases were to some extent also introduction made by colleagues in one area to the disputes team.
That's very interesting. So you worked on these projects at Cleary, and then you joined the ICC after it. It seems I actually remember when you announced it to your friends that you said like, oh, like I have this promotion, I'm going to the ICC, and I remember thinking, well, of course, because I'm not a lawyer, that oh, that's actually not linear, like. So could you maybe tell us a little bit more about what motivated you to put your private practice on pause and then join ICC? What were your thoughts around it?
Yeah, sure. So you're right. It is probably not a very linear move, and I think most people that go to an arbitral institution, be it the ICC or others, rather do it at the beginning of their career. But I think there is a big advantage in doing this actually at the mid or even the late stage of your career, because you understand much more about the market. You understand much more about the field of arbitration. You know what to focus. So you bring both a great set of knowledge to the institution that the institution can profit from, and on the other hand, you can rip the individual position that you have at the ICC much better. My primary motivation was that I wanted more exposure to commercial arbitration. I was doing mostly international law at that point, so I wanted to regain the exposure. I started sitting as an arbitrator as well, so I wanted to train for that. And the ICC is an amazing opportunity for this because you see awards all the time. One of your tasks is to read awards and provide comments on this. So you learn really from the best arbitrators in the world, and it's just an amazing training ground. And generally, the ICC offers you, of course, also a great network. You have just a completely different level of exposure. And by that, I actually don't mean primarily, let's say, conferences that you speak at a lot of events, and which I've done quite a lot, but I mean the day-to-day exposure to professionals. So you speak to lawyers, you speak to being parties' counsels, you speak to actually the in-house counsel, you speak to arbitrator all the time, and it's where you actually develop meaningful relationships to people because you can help them solve a problem. And then in terms of my additional personal motivation is, well, whenever you're in a law firm, you work in parallel, let's say on 5, 6. If you're extremely busy, you work on 10 cases at the same time. But it's still, especially in arbitration at quite a high level, it's 10 arbitrations at the time, which are extremely complex. So you might cycle through them every 3 to 4 years.
Yeah.
At the ICC, I was in charge of a team that had, at any given point in time, 200 cases pending.
Wow.
So I would supervise all of them. So that's a long way of saying that you get to see within a span of 2.5 years that I spent there, probably as many arbitrations as you see in, I don't want to say a lifetime, but let's say 20 years. And maybe 20 years, maybe 30 years in private practice.
Can you maybe, for those who are not very familiar with how the ICC works, explain on a very practical level? So you were a counsel at ICC, and you oversaw 200 cases at the same time. What exactly did it mean? What exactly did you do?
Yeah, sure. So generally speaking, the ICC is one of the biggest, depending on which metric you apply, maybe even the biggest arbitral institution in the world. And what an arbitral institution does is administer the cases. So making sure that the dispute moves forward. So from a moment when a request for arbitration comes in, the institution does everything from notifying the request, making sure the financials are kept in proper order, i.e. all the deposits of funds by the parties are received and arbitrators are paid. Appointing the arbitral tribunal, so making sure that there is actually someone to decide the dispute. And then specifically, the ICC is a very hands-on institution, meaning that many decisions, especially in the phase pre-constitution of the arbitral tribunal, are taken care of by the ICC. So let's say there's a myriad of procedural questions that can arise, and I don't want to bore your viewers with all of them, but the way how the ICC works is there is a ICC court, so the body that takes all of these decisions. It's not like in other arbitral institutions, let's say the Secretary General or a board of directors. It is in body composed of, I think, about 190 lawyers from all over the world, and they come together in various sessions and compositions to take these kind of procedural decisions. And all of their decision need to be prepared. So there is a long memorandum, depending on the complexity. It can be anything from 5 to 50 pages, really going into the depth and the detail and explaining what a procedural decision means. So it's at the same time a very legal job. And I think that takes most of the time that you're spending the ICC. So you're working on the procedural decisions of the ICC court, one thing, keeping the arbitration running. And the third one is the ICC has somewhat of a unique feature, which is called the scrutiny of the arbitral award. So once an draft award is ready by the arbitral tribunal, it does not go straight to the parties as with most institutions. It goes first to the ICC. And at the ICC, I read the entire award. So depending on how long the award is, if it's 50 pages, that's, if you read it properly, it's, let's say, 3-4 hours. And the longest award I had 1,400 pages. So that was basically 2 weeks of not doing anything, including weekends, and just reading this award. And then you provide comments, both on some formalities, but also to some extent on substance, with the aim, not of course to change anything in the reasoning of the tribunal and convince it to decide in a different way. That's not the task at all, but to make sure that the quality of the award is up to standard, because that in the end will ensure that this award will survive and will be enforced. And that in the end is the aim of all the parties. It's lovely to have an award, which is a piece of paper, and you can, as a former professor of mine said, nail it to the wall if you can't enforce it, but it's useless otherwise. So the ICC, that's probably the other 50% of the work of a counsel. And then there's a lot of administration, because a counsel, you're in charge of a team. I had a total of 7 people in my team that helped me with all kind of tasks. We're taking care of all kind of tasks. And as always, when you lead a team, it's also a lot of administrative things.
That's super interesting. Thank you for this insights in the practical side of ICC and of your work. How did your understanding of arbitration and of the market changed after you joined the ICC? Because as you said, in a law firm, you can see 8-10 cases in a span of 2-3 years. Now you're exposed to hundreds of cases, and I guess that you work much closer with the arbitrators, and you see other stakeholders. So what else did you understand about arbitration?
That is a very good question, and I was thinking actually about this now that I left the institution and had some time to reflect. I think there are several answers to this question. One is purely from my personal development. It gives you a very good understanding how arbitral institutions work. And arbitral institutions work differently from arbitral tribunal. Their decision-making works on a different level, and their reasoning is different. So I think, without having ever been on the inside of an arbitral institution, it's very difficult to you just don't know how exactly this reasoning works. And understanding this is extremely helpful, and also for me now, going back to private practice, for the resolution of all the procedural questions, like how do you present and how do you plead a question properly to an arbitral institution, that diametrically changed. And I remember when I was at Clearion, also at my previous law firm, Wilmer Hale, before, we submitted quite a few procedural requests to arbitral institution, and I would certainly do this completely different today. Then you just see the whole of the arbitration world. And I think when you're in big law firms primarily, you get a bit focused, and rightly so, of course, on big cases. Like all disputes you work on are, 10 million is a minuscule case, and cases go into the hundreds of millions and billion, etc. But there is a whole world out there of cases of 50,000, 100,000. Like someone did not pay the bill for the pipes, delivery of some pipes, or some small construction work provided. There's an arbitration for 70,000. This is something you won't see, but it's still part of the arbitration world. And it's very interesting to see how also lawyers that have no experience in arbitration plead these cases. And also, I always believe that you can learn something from pretty much everyone. And so you can also from non-specialized lawyers. And then, as you very rightly said, you just see a lot. You see all the variations of, let's say, procedural orders, ways of drafting submission, of course, because it's a very different way how, say, a local top-tier French firm drafts a submission differs very much from how a New York top-tier firm drafts. And again, you can really learn a lot and take it all into consideration.
Yeah, that's super interesting. And again, from a very practical point of view, and if you can share it, how is ICC funded? Who pays for it? Like, is it the two parties that are in that want their case to be heard at ICC? They contribute their fee and.
Yeah. No, that's public information, so I'm very happy to share it. So the ICC is more than just a dispute resolution ICC. The ICC is the World Business Organization. So its main task in this world is to do business advocacy on an international level. And historically, why the ICC started offering dispute services. And then there are various other services that the ICC offers: events, conferences. There's something called Incoterms, so standard contractual terms that are used across the world. These models are sold. Then there are model guarantees. Whenever you see a bank guarantee in a commercial transaction, there's a chance, I think 98% of them are based on ICC models. And lastly, the ICC has national committees. So let's say domestic arms of the ICC, they're independent entities in association, and they have members. So these members' fees go as well to the ICC to comprise the entirety of its budget.
Okay, no, that's actually very, very transparent. And when parties decide that, okay, we want this, we're going to ICC for our case, what kind of metrics do they expect from you? When would they say they did a good job? I suppose one of the metrics is that my award came in time, but that's just the only thing that I can think of. Probably there are others. How does it work?
Yeah, I think the metrics that clients, and by clients I mean primarily law firms and users, apply is speed, efficiency, of course. So did my award come in time is essential completely, but it starts, I think, already earlier, as in how fast was the request for arbitration actually notified from the day I submitted it. How quickly was an arbitral tribunal constituted when respondent defaulted? How quickly was a procedural request for consolidation or joinder or a challenge treated? So all of these elements, I think, speed, time, as you said, are completely of the essence. And then I think it's just the quality of the work, really. So did the candidate that the institution, that the ICC appointed, was that a candidate that the parties look at and say, yep, no, perfect, like right expertise, right level of experience, language profile, etc.? Or do they look at it and think, oh my God, how did we end up with this person? Will be very, very important. The ICC also, for certain of its decisions, well, the court's decision, provide reasoning, which the parties can request. So this shows, I think, very clearly the quality of the work. And then I think what the ICC does uniquely well is availability and reachability, if that's a word. So the fact that you can pick up the phone and call the counsel, call me, call the deputy counsel in charge of your case, and just ask questions. And I left the ICC now, but I still receive calls from people that I have worked with. They're like, or write me on WhatsApp, like, I know you're not with the ICC anymore, but I have this procedural question I would really like to discuss with you in the abstract. And I am happy to do it because, of course, I'm pleased to be perceived that way. But the ICC, as a general matter, offers that. And I think that the ICC does that among the best of all arbitral institutions. And for me, that's always been one of the best metric to measure our success. That whenever I'm at conferences, people say like, oh, I really appreciate the fact that whenever I have an issue, whenever I have a question, I can pick up the phone and I'll reach you. That's good service quality that I'm always very pleased to hear.
And you become a reference in those matters.
Exactly.
People think that you know this right way, and
yeah, exactly.
It's great that it's. I didn't know actually that you can share it, that it's that approachable. You know, that it's like allowed that you can just like call and ask and.
Absolutely, of course. I mean, of course, you don't. You can't ask things that go to the core of inter partes communication. Of course, there wouldn't be anything shared that is beyond the interpretation of the rules in the abstract. But helping on a specific case to understand certain elements of the rules, yes, absolutely. I think that's the core part. And then whenever you have also for your case something specific, such as you want to call and say like, so I'm contemplating, we can't make the payment right now, we're experiencing the following issues with let's say a case with a sanctioned entity, and we are the team in the end that handled most of these cases. How can we make this actually work? Can you advise us? Absolutely. That's, I think, the core. And maybe just one quick flip back when we're saying about what did I learn when joining the ICC and why it's a good thing to join it a bit later. I think understanding what counsel want, comes with a bit of experience if you've been in their shoes, if you've been practicing. And I think that is extremely helpful because, I know where you're calling. I understand what the concern is. Let me explain to you the situation. And it helps really to be able to make this, to have this experience to help people.
It sounds that what you're sharing is a lot about just building interpersonal relations of trust with all the parties involved, with the counsels and the arbitrators.
Yeah, absolutely. I also believe that this is a core part of any lawyer's, actually in all service areas, also consultancy, of course, it's the core part of the job. There are a lot of competent people, and of course you need to be competent. That goes without saying. But there are a lot of competent people in this world, especially if you play at the very top end of the game, there need to be one distinguishing factor, and it can't be that, in my view, that you're saying, well, I'm 1% better as my competitor, because this 1% will rarely win you cases. But an interpersonal relationship, so that someone trusts you and knows that you are there to support them throughout the entire journey, I think that really matters.
Mm-hmm. For you, if imagine that I want to start building this network of with other lawyers, other professionals, other stakeholders in arbitration and in law more generally. Where do I start? Like, what kind of business strategies I could apply?
I think you start pretty early. I think there's no possibility to start. There's no way that you can say, well, this is too early for me in business development. Like, I'm just a first year associate, or I'm even just an intern. There's just no such thing as too early for business development, because you learn from more senior people how to do this, and B, whoever you meet along your journey to becoming a partner, or wherever it might lead you, will probably be with you along this journey. There might be your peers in another law firm that might give you work if they're conflicted. They might be people that move in-house. They might also just be people that give a good recommendation. If someone asks, like, hey, I'm looking for a good Swiss law firm dealing with arbitration, and then it's like, oh yeah, well, I know Greg just moved to one, you should give him a call. So I think I would start there. And then later in your career, when you get more and more and more exposure, I think it's a bit also just word of mouth. Like, people have seen you. People might have seen you as an opposing counsel, and 3 years later there is another dispute, and it's like, oh, I really liked this person. Let's call them.
Mm-hmm. Mm-hmm.
But that, I think, that comes after years of experience.
Yeah, so what you mentioned is almost like, personal branding, when people get this idea of you, even if they didn't work directly with you, but they saw you in court, and they saw how you are as a professional.
Yeah. I think I completely agree. I think in our professions, personal branding is a core element. And with that, I don't mean post every day on LinkedIn. I think you can overdo this, and there are people that certainly do, and then become influencer, rather perceived as influencer. And I'm not sure that's a good way to brand yourself. But certainly you need to establish a reputation for yourself. But also, now that I think about it, it goes beyond other professions. I'm sure you've, at some point in your life, you've been to a doctor because someone was there and recommended this doctor to you. So in our world, that applies probably even more so, because we have other tools to brand ourselves compared to doctors.
Mm-hmm. Of course. Can I ask you how you brand yourself?
Yeah. I have a bit of, well, I don't think I have a very, very core approach. I have rather say some rules that I apply to myself and try to live by. So of course, part of it is conferences, part of it is publication. I try to avoid, for me, and that's my rule, too many, let's say, soft topics. So I try, whenever there is a publication, whenever there's a conference, I try that this is really a core legal issue, because I believe that this is how you brand yourself as a legal expert in the field. And then on the, say on LinkedIn, on the occasional link, I try to also focus primarily on core legal issues. So not, and if we go into some details, like for example, you notice that a recent judgment of Court X was published, and you think it's very interesting to share this. I would, rather than share like, the European Court of Justice recently issued the decision on X versus Y. Very interesting, full stop, and then a link. That's, to me, a bit pointless. But if you give your quick analysis on this, people remember that you provided some input for them, and that I consider very, very helpful. And to be honest, that's probably it. I think trying to be present without being overly present and focusing on substance rather on just general being an influencer, so to say, which I don't know what your experience is, but I feel LinkedIn is becoming a bit more, especially now with the video functions, becoming more and more a bit of is tilting towards Instagram or TikTok.
You do know that we will publish it on LinkedIn.
I know. And it's but what I mean is, have you seen that there is this video function now on LinkedIn for short clips? Which kind of are the TikTokization of LinkedIn, and I'm not sure I personally am a fan, but then maybe I'm just too old.
No, I'm sure not. But I get what I totally get what you.
I think we're, as lawyers, we're kind of to some extent a conservative bunch of people, and I think it is what our clients want are expertise primarily, and this is what you should also display on in your personal branding, like your core expertise in the areas that you're really an expert on.
I think that you're actually also part of your personal branding is that you're very present, and you're very much available, and you're like here with the good advice. And I know that it's something that is that might seem obvious, but also it's rare to actually be able to WhatsApp someone and have an insight and have replies. So
I appreciate that. I appreciate to be perceived like that. But and you're right. I'm trying to do this. So I'm also, for that reason, I'm teaching a lot. Which now, for example, I'm flying tomorrow to Berlin to give a class at Humboldt University. I've been a visiting professor this year in Turin, and that's something that I do primarily out of enjoyment of it and to give something back. I do believe there is a bit of a business development component in this as well, because your students can be very much your future clients, and I know from partners I've worked with in both at Wittmer and Cleary that some of massive cases, like in the hundreds of millions, they got pretty much from that, because one of their students went back to become the general counsel of a company, and when they had a dispute, it's like, oh yeah, I remember this guy who taught me arbitration. He was pretty good. Let's call them. And the same applies for being approachable. I believe it's just a decent thing to do as a human being. If someone has a question, just take the time for that if you can help, and then sure, hopefully people will remember this once they have another question, or actually have something that is not just a quick question but a case. I'm very glad to be perceived like that.
No, it's very true, and sounds like you have this approach to connections that like last a lifetime, or like at least a career span.
Yeah, maybe that's exactly the point I always consider. I think any form of relationships, including business those that can be part of business development, it's never a quick game. It's always a long term game that you need to play. Whenever you go to a conference, whenever you speak to people, it's not about you come back and you sign a deal for the representation for X. It's building a long-term relationship that can may result in something in a way. And if not, you just spend a good time with interesting people and might be able to help them one day. I think that's already great.
Yeah, absolutely. I have last question about ICC, and then I will ask
Please.
About your next firm. So you mentioned that you were overseeing over 200 cases. Obviously, when you say that, to me, I start thinking that it's almost like a machine. It's at some point it's a number game. So did you use any special technology to in your daily life to be able to handle this volume of work?
Yeah. So the ICC has its own internal database. It's called ICABAS, and it is quite dated. It will be replaced, I think, if things go well, even this year. But this is just an internal organization, an internal tool, a database. It's not in any shape or form an AI tool. I think arbitral institution generally can profit from AI in a way that they just sit on so much information data. And I don't want to go into the question to what extent what they can use, because that's obviously a very complicated one. But as a more general, just the data that is, so to say, available without speaking about submission, etc., is a huge amount of information that an institution can use for purposes of artificial intelligence. I don't think any institution is doing it, maybe primarily because of the complicated questions involved. What institutions do to different extent can benefit more and more from is automatization. So not necessarily AI, because it does not involve, so to say, decision making of computer, but just automatization is an example. Like you at every institution, you need to excuse people that might have a conflict of interest. So that thing, there is a database who is excused on which case, and that, for example, can work pretty automatically internally, that you exclude these people from access to all information rather than doing this manually. The memoranda that I mentioned before can be populated automatically with information from the database rather than drafting them every time from scratch and so on. So I think it's not really AI, but there's still a lot of scope for improvement that institutions can do on the level of simple automatization, which I think is already readily available.
Okay, I understand. So you shared how in ICC you get exposed to many stakeholders, many cases, many arbitrators, how you understand better and differently different challenges that come with the case. How did you choose your next law firm after that? Because you must see so many of them, at least I was going to say at least 400, because 200 cases, 2 parties. Probably some of them are the same, but still, fairly large amount of.
That's true. You see a lot. So yes, certainly to some extent that's an element. You see how certain law firms work, and sometimes you might think like, yeah, I'm really not convinced, but by what they're doing, so I'll certainly take this law firm off my list. But that's more anecdotal, I would say. The main considerations for me were, it was clear to me I would go at some point into private practice. So meaning into a law firm to make use of all what we were talking about before, like all these elements that I learned, understanding the arbitral institution, seeing more submissions, awards, etc. I didn't want to go back into a very big law firm, so the size that I have been before. And the primary reason for this is that I wanted to sit more as an arbitrator as well. And the disadvantage of a law firm, let's say the advantage of the cross selling that we were talking about before, the disadvantage of this, of course, are conflicts. A big law firm has many more clients, but that very much limits the possibilities for sitting as an arbitrator or also getting new clients, because there might be a conflict with existing clients or potential clients. So I wanted to go back into a law firm that is still big, so not a very small boutique, but at the same time not as big that it might create conflicts left and right. So that was first consideration. Then at the same time, I still wanted to go somewhere that is quite international, and that medium-sized but international already limited somewhat. Third, we had personal considerations that we enjoyed our time in Paris, but we're looking for a quieter place, and Switzerland is as quiet as it gets. Probably someone. I was speaking at a conference in your hometown in Tallinn a few weeks before, and all panelists were introduced by what is your midlife crisis thing that you're to. And there were some one was like, yeah, I started weightlifting, I can do now a deadlift of 100 kilogram, and mine in the end was, well, I'm moving to Switzerland to a calmer life. So that was part of the game. And of the Swiss law firms, I wanted the one that is still the most international. And my experience was in the past always the best place you can be is to be in a small team in a large structure, so to say, because you get all the benefits, you get all the interesting exposure, the interesting cases, but you still have the human interaction, and you're not lost in a structure where you're a small wheel in a large machine. And that, to me, really a Swiss law firm very much brings. And lastly, I'm a German lawyer. So it's a German lawyer. Swiss law is very, very similar. So it's much more accessible to me. And my consideration was, if I stay in Paris or go to London, I will probably one of the still many international lawyers. But there is not so much of a USP that I would have. But in Switzerland, I think there is a bit of a USP to have, especially if you're a German lawyer and you can offer Swiss law advice. And Switzerland happens to be a jurisdiction that is so important to international arbitration that it is that in and of itself a USP.
Can you tell us a bit more about this law firm that you're joining? So Schellenberg, Wittmer.
Yeah, absolutely. So yeah, no, perfectly. So Schellenberg Wittmer is a Swiss law firm created through a merger of old Zurich and old Genevois firm in 2000. And it is one of the biggest full-service firms in Switzerland, of about more than 150 lawyers, I think. So offices in Zurich and in Geneva. There is also an overseas office in Singapore, and the firm has a bit of a focus on Asia as well. And it offers full service. So while it's disputes focused, it offers everything from corporate to litigation, antitrust, private wealth, and so on. It is one of the leading firms in Switzerland, recognized pretty much everywhere as a tier one firm. And yeah, it's still among the Swiss firms, arguably the most international, and that's also what I wanted. So to be with a firm that really has an exposure and a network around the world and a name around the world, while still being in a rather small place like Switzerland.
When do you start?
January.
Oh,
January. Quite excited.
Yeah, that's amazing. And do you know already what kind of clients you will be working with?
I think generally it really is across all industries. So, being a Russian native speaker, I have a natural focus on Eastern Europe and Central Asia, but it's certainly not limited to this. To me, the really big advantage of Switzerland is that, well, Swiss law really ends up being chosen so often by companies that are otherwise have no connection to Switzerland just because of, well, of its quality, but also of the neutrality of Switzerland, or Switzerland as a seat of arbitration. And that, I think, will be a large part of the work. But then also, Swiss law firms in general are competitively priced compared to, let's say, American or London firms. I've heard recently that in London, some law firms, the big law firms, are charging now for a first-year associate up to £1,000 per hour. And no, that works on the market, and that's great, I guess. So great for everyone involved. But the thing is, Swiss rates are certainly not as astronomical, while the quality is on par. So I think a lot of work will also be just purely international arbitrations, because that's the big, that's, I think, where Swiss law firms and Schellenberg specifically can be very competitively with the international profile that it has. And a lot of lawyers are qualified additionally in other jurisdictions, or even come from core other jurisdictions, including common law jurisdictions. So that gives Schellenberg a bit of opportunity to work on international cases from Switzerland in a very competitive manner. And lastly, I hope arbitrator work. I had my first requests within the first weeks after I left the ICC, so that's great, because that's, I think, an advantage. Whenever you leave an arbitral institution, you always perceive a bit as an expert and a good candidate to sit as an arbitrator. So hopefully that will continue. And let's see, maybe one thing more is, I think there will still be quite a bit of work sanctions related. So mentioned briefly, I was working before at the ICC. We were the team that had most of the sanction cases, partially simply because I speak Russian, and that obviously is a large part of sanctions related work nowadays. But the other part is that many of them, of the large cases, are also seated in some of the jurisdictions I was responsible for, and I had the benefit of being responsible really for most of Western Europe. So within my team that I supervise at the IC were Germany, Austria, Switzerland, all of Scandinavia, Nordics, Benelux, and many of these disputes have a connection with that. So this expertise, certainly working with disputes involving sanctioned entities, is something I'm looking forward to.
That's super interesting. Thank you for sharing all this. It's given a very interesting perspective on the different aspects of a career in international law. And actually, maybe as a final question, what advice would you give to someone who wants to succeed in this international law as career practice?
It's a good question. The usual things that obviously everyone should say in this is that work hard, etc. But that goes without saying, I think. My personal take is probably that one should not focus, especially in the beginning, too narrow. I had this at Cleary when I had students or interns that were just fresh out of law school, and they say, "Oh, I really want to do only state disputes in the mining sector." And it's like, that's great, congratulations, and whenever you have one, that's amazing. But you probably have too narrow of a focus, especially at the beginning of your career. So my advice would be, don't focus too narrow. Also explore to some extent other areas of law. Like I started doing a lot of when I started back in Frankfurt, the partner I was working for was also litigating many cases before of the European Court of Justice, and asked me would I want to do this, and of course I wanted to, and it taught me so much. So there is I don't want to sound too in love with law, but there is beauty in all areas of law, not only arbitration. And in the end, arbitration is a procedure, but you win a case on substantive law and facts, and there is beauty and exposure to all of these. And my other advice would be the one that I gave before. It's really never too early to do business development, no matter what stage you are. And well, yeah, tying maybe to the first one, that work hard is also just really, you need to provide quality work in absolutely everything what you're doing. It sounds straightforward, but it's easy sometimes to slip, so to say. And you need to remember that it's, and the typical saying is really true, that it's very difficult to build a reputation, but it's extremely easy to ruin it. So that's why I do believe that whatever you do, you should do at the utmost perfection from day one. But that might be really one that goes without saying.
Thank you, Greg.
Thank you.